We are gone past 1:45. We're going to propose to start in public session. Is that agreed? Agreed. Can I remind members and witnesses regarding mobile phones that they would be in the off position, and to those in the public gallery and the media, if they have the phones, please as well. You're all very welcome to this, our 10th and final session in a series of hearings over the last 3 days that the Joint Committee have conducted over the past number of days to discuss the implementation of the government decision following the recent publication of the expert group report in the matter relating to the cases A, B and C versus Ireland. At each session, the committee has heard very thoughtful, very considered and very wise submission and counsel from a wide variety of personnel dealing with a very sensitive and very complex issue. And I want to thank, up to now, everybody who's participated in the hearings for their constructive and informative deliberations. For clarity, I would like again to set out again the background and intended role which these hearings are playing in this important discourse. We're here to discuss the implementation of the government decision following the recent publication of the expert group into matters relating to cases A, B and C versus Ireland by way of legislation and regulation within the parameters of our current constitutional provisions. Government has stated that its aim of its actions on this matter is to ensure clarity and legal certainty in relation to processes for the determination of whether a pregnancy is permissible in case where there is a real and substantial risk to life as opposed to the health of a woman of that pregnancy. In doing so, we must ensure that we are and we take full account of Articles 43.3 of our Constitution. And again, I want to thank all members of the committee and hope that in the continuation in this, the final session, that our process of engagement will again be in a calm, tolerant, respectful manner, allowing for the various opinions that we're going to hear from. With that in mind, I want to welcome most sincerely to our last session from Choice Ireland, Ms. Jacinta Fay and Ms. Abigail Rooney, from the National Women's Council of Ireland, Ms. Orla O'Connell and Ms. Jacqueline Healy, and from Action Next, Ms. Ailva Smith and Ms. Sinead Kennedy. You're all very welcome to our meeting this afternoon, to our hearing today. Can I remind witnesses regarding privilege that witnesses are protected by absolute privilege in respect of the evidence you are to give to the committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter to a qualified privilege in respect of evidence, and you are directed that only evidence connected with the subject matters of our proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise nor make charge against any person or entity in such a way to make him or her identifiable. And members are reminded of the long-standing parliamentary practice or ruling of the chair to the effect that, where possible, you should not comment on or criticise nor make charges against any person either outside the House or an official by name in such a way as to make him or her identifiable. And before I begin proceedings, could I get permission from the members of the committee just that at the end of our deliberation we would have brief words of address from the spokespersons of the parties. Is that agreed? Agreed? Gramargo. Thank you. Okay, it's now my pleasure to call on Ms. Jacinta Fay, I think, of Choice Ireland, or Ms. Abigail Rooney to begin, please. Thank you.
Choice Ireland, first of all, I'd like to thank the committee for the opportunity to put forward the voices of the young women of Ireland who are at reproductive age and who will be the most affected by this legislation. We would like to congratulate the government on finally commissioning a report on this and assuring the Irish public that legislation and regulations will be implemented in a timely manner. We would also like to congratulate them on the success of the hearings over the past few days, and hopefully this will encourage future dialogue on the wider issues such as rape, incest, health, fatal fetal abnormalities and so on. Choice Ireland is a Dublin-based feminist pro-choice group which has been active since January 2007. We're a volunteer-run organisation campaigning for free access to accurate information on all crisis pregnancy options, proper sex education, free access to quality childcare, and free and legal abortion. We've been campaigning since our foundation for the legislation of the X case and welcome the government's decision to address this issue after 21 years of successive governments failing to do so. The UK Department of Health Statistics suggests that 4,149 women provided Irish addresses to UK clinics providing abortion services in 2011. In addition, statistics compiled by the Crisis Pregnancy Programme indicate that some 1,470 women travelled from Ireland to the Netherlands from 2005 to 2009 to terminate their pregnancies. In addition, seizures made by the Irish Medicines Board suggest that many Irish women terminate pregnancies within the state by ordering medication over the internet, which is an incredibly risky situation for these women to have resorted to self-medication. Currently, abortion is illegal in Ireland, save in cases where there is a real and substantial threat to a pregnant woman's life, which may only be addressed through the termination of her pregnancy. This right was established following the 1992 Supreme Court ruling, X versus the Attorney General. However, no legislation has been provided in order to give effect to this right. Two subsequent referenda in 1992 and later in 2002 attempted to remove suicide as a potential ground to terminate a pregnancy. However, both were defeated. No known cases have arisen since from suicidal ideation, and one can only assume that due to the lack of clarity within Irish law, many women will choose to travel abroad to terminate their pregnancies rather than face the Irish legal system. In 2010, the European Court of Human Rights ruled that Ireland was in violation of the European Convention on Human Rights, as women had no mechanism allowing them to establish whether they had a right to an abortion in the state under the terms of the X case. The grounds under which abortion is allowed under the terms of the X case are strictly limited and would likely only affect a very tiny proportion of the thousands of Irish women who terminate their pregnancies every year for a multitude of valid reasons. Choice Ireland welcomes the government decision to legislate for the X case, but it is important to be cognizant of the fact that abortion access will only continue to be strictly limited and will remain one of the most restrictive regimes in the world. It is also important to note that legislating for the X case will not lead to a legal situation similar to the UK. The UK abortion legislation allows for abortion in cases where there is a grave risk to the physical or mental injury to a woman. Injury as opposed to death is the critical difference here. Our Constitution gives the fetus an equal right to life as the woman. It would simply not be possible to legislate for abortion in terms of physical or mental injury in this country, save for circumstances where that injury led to a substantial risk to the life of a woman. Further constitutional change would be required to do so. And in saying that, our Constitution still does not recognise a woman's right to a termination in cases of rape, incest, fatal fetal abnormalities, health, or any other of the multitude of valid reasons that abortion is legal in the vast majority of other developed nations. Let us again consider the case that has brought us here today. A 14-year-old girl pregnant as the result of rape, incredibly distressed and preferring to end her own life rather than be forced by the Irish state to continue with her pregnancy. She took her case to the Supreme Court to have her constitutional rights vindicated and won. We are here today, 21 years on, to discuss what processes and procedures should be in place to ensure that when the life of another pregnant woman is in jeopardy, be it due to physical ailments or a risk of suicide, that her constitutional right to a termination is vindicated. Choice Ireland agree with the European Court of Human Rights that women should have an effective means to access their human right. This is potentially going to be a very distressing process for a woman to go through, and any procedure that is put in place to measure whether her life, as distinct from her health, is at risk must be compassionate towards the patient and consider each case in a respectful and timely manner. Now, Jacinta is going to go through some of our recommendations from the report.
5 minutes remaining.
Now to move on for our recommendations for implementation. Firstly, to address the qualifications of doctors involved in the process. The expert group report offers a number of options in this regard. Limiting the number of doctors eligible to determine risk to life to those on the specialist register may unnecessarily restrict the numbers of doctors available to make such determinations and therefore reduce women's access to a termination. Choice Ireland recommends that medical practitioners eligible for specialist registration but not actually registered be allowed to make determinations regarding risk to life. This option balances the necessity for doctors to have the necessary expertise to make determinations with ensuring that a sufficiently wide pool of practitioners is available to ensure women have access to terminations. Then to move on to the number and role of doctors. Choice Ireland agrees with the statements of the Master of the Maternity Hospital of the National Maternity Hospital that a multidisciplinary approach should be implemented using the skills of the necessary experts. Choice Ireland recommend that where practical, the determination should be made by doctors who are already involved in a woman's medical care, and the numbers of doctors required as signatories should be limited to 2 in order to reduce the potential stress associated with this process. In addition, this option avoids limiting access to terminations for women in areas where a wider pool of experts is unavailable. The expert group report proposes that in cases where a woman's life is in jeopardy due to a threat of suicide, that 3 opinions be sought, that of an obstetrician in addition to 2 psychiatrists. Choice Ireland recommends that in such cases, 2 opinions should be deemed sufficient. This avoids the risk of stigmatising women through the differential treatment of physical and psychiatric threats to life. With regard to emergency situations, in order to avoid delays occurring in cases where there is an immediate threat to a woman's life and it is not possible to secure medical opinions following normal procedure, emergency provisions should be clearly laid down to allow doctors to treat women in these situations. Then to consider the recommendations on locations. The expert group recommends that in order to defend and vindicate the right to life of the unborn, terminations at the fringes of viability, even when survival is not anticipated, should take place in medical facilities which have neonatal intensive care units and carried out at such a time and in a manner as to maximise the fetal chances of survival without compromising the right to life of the woman. It is important that this provision does not reduce women's access to terminations, particularly in cases where a woman is being cared for in a facility which does not include a neonatal intensive care unit, and compelling a woman to travel in order to access a termination would pose additional risks to her health. In terms of the review process requirements and attributes, Choice Ireland recommends that in cases where a woman is denied access to a termination in the first instance, that any appeal is carried out by a medical rather than a quasi-judicial review panel in order to reduce the stress placed on a woman seeking a termination by the process. Women seeking a termination should be provided with access to independent legal support in addition to access to a detailed explanation of the grounds under which her initial application was refused. This is to ensure that in cases where a woman feels that her request for termination was refused following a failure to follow due procedure, that recourse is available to highlight this concern. We would also be cautious that any appeal process should be specifically set up for the woman concerned and not for a third party. Then, considering access to the courts, the expert group notes that while any legislation does not undermine a woman's existing right to appeal any decision through the courts, a number of options exist regarding how this could be effected. In order to ensure that a decision is made promptly, it would be desirable to put in place specific rights to appeal in order to achieve a timely resolution. With regard to conscientious objection, practitioners have a right to conscientious objection, and the expert group report notes that doctors who hold such an objection have a duty to refer to another doctor who is not a conscientious objector. In an emergency situation, however, conscientious objection should not delay or prevent a woman from receiving treatment in cases where another doctor cannot be found to carry out the procedure. Then, considering the appropriate monitoring system, the expert group report suggests that statistics are required to inform policy, as well as to ensure that the principles and requirements of the system are being upheld. These statistics should be freely available to the public and civil society. Due to the stigma surrounding abortion in Ireland, however, and in order to prevent any potential pressure being brought to bear on physicians who carry out such illegal abortions, care should be taken to protect the privacy of both women who request a termination and also the treating physician. And finally is our recommendation on whether there is a need for new legislation or amendment of the 1861 Act. The European Court of Human Rights judgment in ABC v Ireland notes that the 1861 Offences Against the Persons Act represents a significant chill factor for physicians. We recommend repeal of sections 58 and 59 of the 1861 Offences Against the Persons Act so that women in crisis pregnancies and physicians carrying out their duties in good faith are not faced with possible penal servitude. In conclusion, I would like to add that everyone wants to see a reduction in the numbers of abortion, as no one should ever be faced with this decision. But the criminalisation of women who wish to obtain abortions is not the answer. The only effective and compassionate means of reducing overall demand for abortion is by providing free and easily accessible contraception and fully comprehensive sex education, alongside a strong social system that supports the women and men of Ireland to care for their children with dignity and respect.
Thank you very much indeed. And I want to call on Ms. Orla O'Connor from the National Women's Council to make remarks. You've got 10 minutes.
Sure. Thank you, Mr. Chairperson, and thank you to the committee for inviting the National Women's Council of Ireland to present to you this afternoon. The National Women's Council of Ireland is the national membership organisation of women's groups and women in Ireland. We currently have over 160 member organisations representing a wide and diverse range of women's groups throughout the country. And our mission is to achieve women's equality, empowering women to work together for the removal of structural, political, economic, cultural and effective inequalities. The National Women's Council really welcomes the announcement by the government to introduce legislation and regulation for abortion as recommended by the government's expert group. We recommended that this was the only way to give effect to both the Supreme Court judgment in 1992 in the X case and in the European Court of Human Rights in its judgment for A, B and C. So we welcome the opportunity to contribute to the discussion on the forthcoming legislation, and we want to make 4 key points. Firstly, the National Women's Council of Ireland has worked on the issue of abortion for over 30 years, and our position on abortion has developed over time in recognition of the diversity of views and perspectives that women have on the issue. The National Women's Council is well placed to make a considered contribution to the current debate, and we have been mandated by our vast and diverse membership to adopt a pro-choice position on abortion. And this position is rooted in an analysis of gender equality and of women's human rights. Most recently, the National Women's Council has led an online campaign to legislate for X, and I know some of you will be aware that over 72,000 emails were sent to TDs from over 16,000 women and men in every constituency in Ireland. We have the support of our membership in calling for the provision of abortion in certain circumstances, in particular the situation where a woman has a life-threatening pregnancy, including the risk of suicide. This support has also been reflected in recent opinion polls, which reveal that 85% of the population support abortion where the woman's life is threatened, including by suicide. Irish laws are clearly out of step with public opinion, and the time has come to introduce legislation as a matter of urgency to provide access to abortion services in Ireland. And our role is to give voice to the experiences of women in Ireland who remain largely voiceless in this debate due to the stigma that surrounds abortion in Ireland, and to support women's access to reproductive health. So in terms of the legislation, from our perspective, in the first instance, it must provide for an immediate repeal of sections 58 and 59 of the Offences Against the Persons Act of 1861, which criminalise abortion in all circumstances. As the European Court of Human Rights observed in its A, B and C judgment, the criminal provisions of the 1861 Act constitute a significant chilling factor for both women and doctors in the medical consultation process, regardless of whether prosecutions have in fact been made. And as the UN Special Rapporteur on the Right to Health, who stated in his visit to Ireland just in December, just last month, criminal laws and other legal restrictions disempower women who may be deterred from taking steps to protect their health in order to avoid liability and out of fear of stigmatisation. Our members have reported to us that women accessing counselling services on their options in a crisis pregnancy situation are terrified of the possibility of going to jail and feel like criminals, and felt that even in accessing lawful information services that they may be doing something criminal. And this is absolutely unacceptable, that women are made to feel like this by a completely outdated and archaic law, which, as we said, backdates to 1861. So it's the view of the National Women's Council that abortion must be decriminalised if legislation and the regulation approach is to be accessible and effective, and to remove the shame, stigma and discrimination that women in Ireland have to endure as a result of these criminal provisions. Secondly, the National Women's Council is advocating that the legislation must also provide for regulations that allow for a practical assessment by doctors and women of a real and substantial risk to the life of the pregnant woman. It must also provide for an accessible review framework to examine or resolve differences of opinion between a woman and her doctor or doctors. The legislation and regulation must provide for a duty of care on health service providers to ensure that women receive appropriate information and care, including post-abortion care. The regulations must place a woman's right to reproductive autonomy at the heart of all procedures and services. And this autonomy is reflected in the expert group's report in its chapter on the general principles that should apply to the implementation of the European Court of Human Rights judgment. This can be achieved by ensuring that the proposed regulations and procedures and services created by them undergo a gender mainstreaming process so that they are gender sensitive to the particular needs of women and respect the capacity of each woman to make decisions concerning her own reproductive health. Gender mainstreaming our health policy planning and service delivery is a very firm commitment of the government under the National Women's Strategy, which continues until 2016. And furthermore, we believe that it's important that all reproductive health services are physically and financially accessible to all women in Ireland without any discrimination. Over the years, our members have communicated to us the lack of agency that women feel while accessing reproductive services in Ireland. So it's very crucial that women are active participants in relation to the reproductive health in conjunction with their doctors. And lastly, the legislation and subsequent regulations must cover the threat of suicide as a real and substantial risk to the life of the mother. There are cases where the risk of suicide would constitute a ground for abortion, and women must be viewed and trusted as individuals having agency and capable of making considered decisions about their own reproductive health. There should be proper and fair medical assessment procedures in place to assess whether the risk of suicide constitutes a real and substantial risk, as provided for in the X case. It is both insulting to women and to people with mental health difficulties for groups to claim that women will be likely to fabricate suicidal tendencies in an effort to seek access to abortion in Ireland. There have been and there will continue to be cases where a crisis pregnancy might trigger or could aggravate existing mental health conditions, and the legislation and regulation should reflect this. So in conclusion, the National Women's Council urges the Government to implement legislative measures as a matter of urgency that would decriminalise abortion, cover the situation of life-threatening pregnancies, including the risk of suicide, and place women's reproductive autonomy at the heart of all procedures and services. But it's critically important as well to acknowledge in these discussions that introducing legislation that gives effect to the X case will place Ireland with one of the most restrictive abortion legislation and practices globally. For many of our members, particularly for women who have had abortions as a result of fatal fetal abnormalities and as a result of rape, this legislation will not provide an answer. And for the women today, over 4,000 women per year, who are right now travelling to the UK and beyond, Irish law will still provide no support and no resolution for them. The National Women's Council believes that achieving access to safe and legal abortion is critical. Women in Ireland must be in a position to make personal decisions about their own bodies and healthcare, free from coercion, discrimination and threat of incarceration. Legislation to give effect to the X case is the urgent and outstanding issue, and the National Women's Council really urges the introduction of this legislation early in this year. Thank you.
Thank you. And our final speaker is, I think is it Alva or Sinead? Alva Smith from Action Next. Alva, thank you.
Thank you, Mr. Chairman. Action on X very much welcomes this opportunity to make a presentation to the Joint Committee on Health and Children and to contribute to this public discussion on the issue of legislating for abortion in Ireland. This is, in many respects, I think, a historic event, and not least for those of us who have been seeking to achieve reproductive integrity, autonomy and choice for women in Ireland since the late 1970s. Formed in 2011, Action on X is an alliance of groups and individuals, including Irish Choice Network, Choice Ireland, Irish Feminist Network, Feminist Open Forum and others, who call on the Irish Government to act immediately to implement appropriate legislation on the right to abortion in Ireland. And I will straight away outline the views of Action and X at the present time in relation to the issue of abortion. Along with our colleagues from Choice Ireland and the National Women's Council, Action on X is calling for immediate repeal of Articles 58 and 59 of the 1861 Offences Against the Person Act, which criminalise both doctors performing abortions and women who have them. We very much agree that the chilling factor which the European Court of Human Rights spoke about and which Dr. Rona Mani from the National Maternity Hospital spoke about so tellingly the other day is indeed a very significant impediment for women. There is no good reason, we believe, why this punitive law cannot be repealed without further discussion or delay. And to those who have said, indeed, in this chamber that there's no need to repeal the sections of the 1861 Act, since no criminal charges are ever brought, we would reply, all the more reason then to delete these obsolete and redundant but still chilling clauses. Next month will mark the 21st anniversary of the Supreme Court ruling in the X case, interpreting Article 43.3 of the Constitution as permitting abortion where pregnancy poses a real and substantial risk to the life of a woman. Following the fourth expert group report on abortion in Ireland, Action on X now welcomes the government's decision to introduce legislation combined with regulation to implement the X case ruling. We welcome the decision as a necessary step required by the Constitution, and also so as to ensure our compliance with the European Court of Human Rights ruling in the ABC case, and also with the European Convention on Human Rights. We are, however, strongly opposed to any dilution of the already restrictive terms of the Supreme Court ruling in X, and would emphasise that the new legislation must fully acknowledge that a risk of suicide due to unwanted pregnancy, as determined by health professionals, is grounds for abortion in Ireland. Indeed, in Action on X, we have been very surprised of late by the readiness of some organisations to question or dismiss the Supreme Court ruling in X. And since when, I ask, do we think it's acceptable in this country to dismiss, disregard or seek to tamper with the rulings of our Supreme Court, or indeed to ignore our duties and responsibilities under international law and international human rights instruments? Action on X is also of the view that legislation must make clear that preservation of the woman's life is prioritised in any clinical assessment on the need for a termination. It must acknowledge that while Article 43.3 requires that a risk to life be real and substantial, such risk to life does not have to be inevitable or immediate, as is set out clearly in the X case ruling. As regards implementing legislation quickly, as a minimum basis for abortion law in this country, the framework for such legislation exists already in Deputy Claire Daly's Medical Treatment, Termination of Pregnancy in Case of Risk to Life of Pregnant Women Bill of 2012. So there is no excuse for any more procrastination and beating about the bush in this regard. In framing a law within the confines of Article 43.3, we would ask legislators to acknowledge the real-life truth that abortion is an everyday fact of life for women in Ireland. Over 4,000 women and girls go to Britain and beyond for abortions every year. They do so because they can't have an abortion here, and they do so for very many different reasons. All of these women make valid and often difficult choices. Some choose abortion because to continue the pregnancy would damage their physical or mental health, or possibly endanger or even shorten their lives. Some do so because they become pregnant following rape or incest. Some do so because of a lethal fatal abnormality, and I regret that it wasn't possible for the group Terminations for Medical Reasons to make a presentation, to be invited to make a presentation to the subcommittee. Further, Article 43.3 of the Constitution is the source of inequality of access to medical treatment between women and men, as was noted by Minister for Justice Alan Shatter during the November 2012 debate on Deputy Claire Daly's bill. The Minister stated then that legally women are denied access to certain treatments, that is abortion, to protect their health, whereas men face no legal denials to any treatment. This inequality is particularly acute for women who do not have the money or are too ill to travel abroad for an abortion. For these women, permanent damage to health or avoidable shortening of life may be the outcome. We believe that this discrimination must end, and we call for an acceptance that risks to health are equally valid grounds for abortion as risk to the life of the woman, and as was indeed recognised by the Labour Party in its pre-election promise of legislation in this domain. The blunt reality is that the restrictive terms of the X case ruling would exclude the large majority of women who in fact leave Ireland every day, every week and every year for an abortion abroad. We therefore, in Action on X, call for the repeal of the demonstrably unworkable Article 43.3 and for appropriate legislation to end inequality and to meet women's actual needs. In Action on X, we support a woman's right to unfettered choice on whether or not to continue a pregnancy. We strenuously object to claims that the floodgates will open and that there will be an explosion of abortion in Ireland. We can predict with considerable accuracy that something in the region of 4,000 to 5,000 women would seek abortions in Ireland annually. This would not be an explosion, but consistent with our true abortion rate and comparable to rates in many other countries. The difference is that at last we would, as a country, be honest about the realities of women's reproductive lives, choices and needs. The change in culture feared by some previous contributors to these hearings, I should say, has already taken place. Over the past 30 years, public opinion on abortion has changed profoundly. The Red C poll, conducted at the end of 2012, revealed that over 80% of the population now believe that abortion should be available to a woman where continuing a pregnancy would damage her health or would threaten her life, and that indeed 36% think a woman should have the right to choose whether or not to continue a pregnancy. And I would add a footnote to this, that polls also reveal that the authority of the Catholic Church has significantly declined, some would say plummeted, over this period of time. For example, the Irish Times Ipsos MRBI poll in June of 2012 shows only 34% of Catholics attending Mass at least once a week, while the Contemporary Catholic Perspective survey of February 2012 reveals that 75% of the respondents do not believe the Catholic Church's teachings on sexuality are relevant to themselves or to their family. Ireland is not only constitutionally, but also, it would appear, socially, a manifestly secular democracy. In conclusion, with these issues in mind, the public support for increased access to abortion, the women and girls who travel abroad for terminations for medical reasons, to preserve their health or prolong their lives, and the unequal access to medical treatments between women and men, Action on X's view is that the new legislation must make access to abortion a real rather than a theoretical right. And I will finish by quoting something that our then President, Mary Robinson, said following the Supreme Court ruling in X in 1992. She said then, she talked about the very deep crisis within ourselves, saying, "I hope we have the courage, which we have not always had, to face up to and to look squarely and to say, this is a problem we have got to resolve." Action on X shares our former President's hope. Thank you very much for listening.
Thank you very much indeed. And it now moves into the realm of the members, where we have 60 minutes for the members, and I'll ask Deputy Kelleher to...
Yeah, thank you, Chair. Just to welcome the witnesses at this session. I just say at the outset, I mean, we're dealing with the fallout from the X case on foot of Article 43.3. So our deliberations are quite confined, as you can understand, in terms of what the legislator can do or could do or is willing to do. So obviously those questions will have to be decided by the members of the Oireachtas when we see government legislation. But just on the issue of Article 43.3, I mean, I assume your organisations are accepting that that in itself is too restrictive anyway. And the interpretation by the X case means that it's only going to be a very limited, if government legislates, limited number of abortions carried out in Ireland anyway. I mean, we talk about the fact that maybe up to 30 abortions are carried out in Irish hospitals every year to save the life of the mother. So there won't be a major change in terms of the numbers carried out in this jurisdiction if legislation is published and passed as is envisaged by the government. But just on the broader issue, because we've had a lot of deliberations on this particular issue, the issue of suicide, certainly some views have been expressed by members and by witnesses that there is a concern about the interpretation of the threat to the life of the mother and suicide being used as a reason. And obviously we've had psychiatrists in here who've expressed views that there is ability by clinicians to assess the likelihood of suicidality, and that was stated quite clearly. Equally, we've had other psychiatrists in here telling us that it is not possible with any degree of certainty, and we have to listen to that view as well. But my concern, or question really, not concern, my question is that even if we pass legislation, we will still have over 4,000 Irish women every year going abroad. And just in the broader policy issue, is there any form of follow-up, or in your experience, follow-up support in meeting the needs of women who've had a termination outside of this country in terms of aftercare, healthcare, both physical and psychological? And is that something that, you know, regardless of what happens with regard to this legislation, we still will have that issue day in, day out of Irish women going abroad and coming back? And is there any mechanisms in place, or should there be further mechanisms put in place to assist women who return to this jurisdiction after termination in aftercare, both physical and psychological? So it's just more of a question on the actual policy, because the views that have been expressed by the witnesses here in this afternoon session, we are confined by what is can be done, and some people welcome that confining. Let's say not everybody agrees that there should be an opening up of a more liberal abortion regime in this country, but at the same time there is an obligation for us to bring clarity to the medical professionals and women when their life is at risk, and that certainly is something that I think all members of the committee agree with. But just finally, in repealing sections 58 and 59 of the Offences Against the Person Act, quite clearly the repealing would be to allow, to take away the chill effect for clinicians in carrying out their duties. But I assume that they would obviously have to still be sanctioned in terms of ensuring that you wouldn't have the development of backstreet abortions or other types of illegal abortions being carried out in the state, that there would still be criminal sanction to ensure that abortions are carried out in specialist hospitals only by people of suitable qualification.
Thank you, Deputy. Deputy Caoimhín O'Connor.
And again, I welcome each of our contributors here this afternoon. Many of the questions over these 3 days have been repetitious. I've tried to find something different and new in each of your contributions. I think I may have picked up on one or two, and I'd like to just develop it with you. In Choice Ireland's recommendations, 3.1 qualifications of doctors involved in the process, you state that Choice Ireland recommend that medical practitioners eligible for specialist registration but not actually registered be allowed to make determinations regarding risk to life. Would you elaborate on that and explain why it is that you believe that the some 18,000 registered medical practitioners with the Medical Council is insufficient to provide in all of the situations that could present? And what exactly do you believe can be achieved by those who are not eligible? I pose the point, we had an interesting presenter here yesterday who's a practicing barrister, but he's also entitled to be a registered member on the Medical Council register. Are we suggesting that he would have that opportunity to make such a determination? In relation to the National Women's Council of Ireland presentation, I thank you for that also. And you do highlight a very important point. And much of what we're addressing is in the whole area of equality and fairness. And you speak of it is important that all services are physically, which many have addressed, but uniquely, you also point out, financially accessible. And this is an uneven and unequal society. And I think it is very, very important, and not least today when it's already signalled with the publication of the so-called HSE service plan and some 40,000 less people with medical cards in the course of this year. How do the National Women's Council of Ireland suggest that there will be equality of access to whatever range of treatments and supports that women may require? And finally, and Billy beat me to it, Alva, I have it to say it was the phraseology in relation to the Articles 58 and 59 of the 1861 Offences Against the Person Act. You state immediate repeal. My little notation beside that was, but surely also its replacement, because what we can't see is a vacuum or a void whereby illegal activities, illegal abortions in a changed situation would be allowed to go unchallenged and without an appropriate sanction.
Thank you, Deputy. Deputy Seamus Healy.
Thank you, Cathaoirleach, and I welcome the witnesses and the submissions. And as Deputy Quaylen has said, many of the questions here are repetitious, and the newer ones, of course, have already been identified by both Deputy Kelleher and Deputy O'Quail on the question of eligibility and the question in relation to the 1861 Offences Against the Person Act. But generally, could I just ask for clarification that the submissions, the groups with submissions are supporting the expert report recommendation of legislation and regulation as being the preferable procedure here. There has again been the suggestion, particularly in relation to suicide, that women would manipulate their doctors. And I would ask maybe for a comment on that from the witnesses. The question of appeal and review obviously is one that has been raised in the submissions as well, and I just wonder if you would clarify maybe and expand a bit on that, and particularly in relation to the time element and the timeliness of any review procedure in relation to this particular issue. Finally, we've had recommendations in the course of the last few days, and particularly for some of the legal representatives who suggested that the whole issue of fetal abnormality could and should be dealt with in this legislation. Maybe you might comment on that as well.
Thank you. And I'll ask Ciara comment.
Thanks very much, Chair, and to thank all the contributors for their presentations. I suppose a lot of what I wanted to ask has been asked there in the previous questions, but there's just something that I wanted to maybe elaborate a little bit from Choice Ireland's presentation in relation to statistics that you quote from the UK Department of Health Statistics that suggests that just over 4,000 women provide Irish addresses to UK clinics providing abortion services in 2011. And we had, again, another flip-flop in relation to this. In the presentation just before years, we were told that there was a Freedom of Information request sent to the Department of Health in England and that no women, Irish women, were sent to abortion clinics. Now, I don't believe that to be the case, but I just wanted to say, I wanted you to come back, maybe have an opportunity to elaborate on that in relation to it. The other thing that I also want to thank you for bringing into the public discourse in your presentation is in relation to what the Irish Medicines Board suggest about how many Irish women terminate their pregnancy by trying to order a concoction or a medication, for want of a better word, over the internet, and how we as a government need to face up to that, and maybe what ideas all of you would have in how we can combat that particularly dangerous procedure that often women in crisis find no alternative to. Thanks very much.
Thank you very much indeed. Okay, so we'll ask Ms. Foy maybe or Ms. Rooney, whichever. Thank you.
I'll try and go through these in order. So the first one, the 30 abortions a year taking place due to physical ailments. Yeah, sorry, Deputy Gallagher. Firstly, the suicide issue. As a woman and an equal citizen of this country, I find it incredibly insulting that somehow you seem to think that I would somehow